They're asking us to prohibit the use of the word profiled, and I understand from the content of the remainder of their motion that they believe we are going to frame that the defendant racially profiled Trayvon Martin. But I would submit to the court there are a number of ways a person can be profiled. They can be profiled by their age, their dress, the car that they drive, the location and timing that they're in a certain place. So that is not a racially charged term unless it's made so, and we don't intend to make it a racially charged term. Judge, the next three, vigilante, self-appointed neighborhood watch captain, and wannabe cop, again, there's nothing prejudicial about any of those terms. They're not racially charged. There's no case law that prohibits the use of any of those terms. As a matter of fact, I believe it would be incorrect to say he's the self-appointed neighborhood watch captain. He initiated the neighborhood watch program for their retreat at Twin Lakes, and then he was later appointed the captain. So I agree. Again, I don't think it's improper if it was a fact, but I don't believe it is a fact that he was the self-appointed neighborhood watch captain.
It was quite apparent that when you use the word profiling, it's like peanut butter and jelly, profiling and racial in a case of this magnitude, and the focus that this case has had for the past 15 months. So we have tried so hard in this case not to make it what everybody outside the courthouse may want it to be, and it's just being caught.
Don't you think that neither side wants that to happen and to have those kind of errors occur in the trial? I would say I would ask the state to stay away from racial profiling, but not the word profiled itself if it's used in other terms. Term vigilante usually would be used during a closing argument, but if that's something that they want to do in their opening, I'm not going to prohibit that. The self-appointed neighborhood watch captain, with the state had indicated that statement that you have in quotes, that they agreed that that's not what had happened, that he had initiated the neighborhood watch program and was appointed captain and may have had the involvement, and that's the way that they're going to use it. Wannabe cop, I think that that's appropriate. The state has acknowledged that your quote, he got out of the car after the police or dispatcher told him not to, was factually incorrect, and they can state the factually correct statement. He confronted Trayvon Martin, that statement. That is the state's case, and so they will be allowed to do that.